Parties may come forward in the matter of Cotran and Cotran. And Attorney Gordon, you'll correct my pronunciation if to the extent is necessary.
This is case 2011-0216 in the matter of Stephen R. Cotran and Diane M. Cotran.
Mr. Gordon, is that your client?
That's my client, Mr.
Thank you. And just so Mr. Cotran understands, the only reason, it may seem odd to you, but the only reason that Mr. O'Meara was allowed behind the bar is because he's a member of the bar. It's not intended as a slight against you at all. Thank you. Mr. Gordon?
My client's name is pronounced Cotran, thank you.
Thank you.
May it please the court, I'm Joshua Gordon. I represent Stephen Cotran, who tried to sell his Antrim property. The agreement between he and his ex-wife said the land shall be immediately placed on the market for sale. And this is a landlocked timber lot. He had it listed on MLS, it's a multiple listing service, before in 2009, but it didn't sell. After the agreement, he had plenty of incentive. He had a year and a half to sell it or come up with the money. So he put up a for sale sign and he tried to pitch it personally to potential investors. When that didn't work, he relisted it with MLS. When that still didn't work, he borrowed the money and paid Diane anyway before the deadline.
There was no requirement in the parties' agreement for an MLS listing.
No requirements whatsoever. The agreement said immediately placed on the market for sale.
Is there any disagreement about whether he immediately put the for sale sign up and entered into a listing agreement with his own agency?
The record says 2 weeks. I think in the context of this, that's fairly immediate. He was in complete compliance with the agreement, and so he avoided damages. I think if Ms. Cotran were here today, I imagine her argument would be that they were both real estate professionals and thus they both assumed multiple listing service. Well, you know, from the record, this course of conduct looks like something only two real estate brokers could come up with, but both knew there are plenty of ways to sell land. Even if Diane disagreed with Stephen's wisdom on the aging of property and the best way to sell it, she had to have understood that non-MLS was a possibility.
But you know, I guess what I'm curious about is, isn't this really a sort of a factual issue as to what the parties should reasonably have understood their agreement to be? And I assume that well, it should have been listed on MLS, no, it shouldn't have been, that was customary, no, it wasn't, were things that were heard by the trial court. And why isn't that a factual decision for the trial court to make?
Because the words, what does for sale mean, are much greater than two people. And, you know, so I think this court should go so far as to make that decision and write a published opinion on it, because there are few nationally. But, you know, what does a place on the market for sale mean? Does it really mean multiple listing service if the parties didn't specify that? Multiple listing service is that would be.
I guess what I'm really asking is, isn't this to some? I mean, if he just, should we say as a matter of law that just putting, you know, if there's an agreement in which I say I'll sell my house, that as long as I put a for sale sign out on the house, out on the front lawn, even if I don't do anything else, that as a matter of law I've complied? Or is it really sort of a factual issue of, well, did the person comply? There's an obligation in contracts of, you know, fair deal, good faith and fair dealing. That couldn't the court have said, you know, as a factual finding, I find that he did not do what it was contemplated he would have done within the realm of what reasonable people entering into such an agreement would understand.
Contract terms are a matter of law, and I don't think there's much way around that. Certainly, you know, what he did, whether he put the sign out or not, or what day he put it out, those are factual issues. But what is the meaning of the word immediately placed on the market for sale? That's a legal issue.
Did the court have before it evidence of soliciting buyers privately? You say that in your brief. What was the evidence on that?
I think that Mr. Cotran testified to it. There was nothing beyond that.
Nothing beyond that, but he's testified that he actively solicited buyers.
And he testified that there were some timber buyers, because after all, it's a timber property. But he had no reason to lie about it. He wants to sell this thing. He owes this woman a whole bunch of money that he doesn't have. He has every incentive in the world to sell it. There's nothing in the record suggesting that he has some emotional or other attachment to the land. He wanted to sell the land just as much as she did, so he tried MLS. That didn't work. He tried private pocket listing.
And there was
that didn't work.
evidence that in the past he had tried to sell this land and was unsuccessful.
Pardon me?
There was evidence that in the past he had listed the land through MLS trying
Yeah.
to sell it and was not successful.
Correct, yes, that's in the record.
And can I just ask you, was there evidence on the point of, you raised the issue of, well, there hasn't been a showing that even if he had put it in MLS, it would have sold any faster. I mean, what was the evidence on that at the hearing?
I don't think there's any evidence at all. What I was suggesting is that Diane didn't come in and say, in that year, 2010, I think, there was, lots of timber lots of timber sales or something like that.
So there was sort of an absence of evidence that it would have sold more quickly if it had been put on MLS.
Correct. And putting MLS as a sales method, that would be an express condition of the contract. And had Diane or had the parties negotiated that, that would be specifically enforceable. But this was placed on the market for sale. That leaves methodology open. And as I suggested in my brief, there are numerous methodologies for sale, and MLS is just one of them. So much so that you don't get antitrust out of MLS. So he could place it on the market for sale in any way he wished, and there's no evidence that he was somehow not diligent in selling.
Thank you, Mr. Cole.
Thank you.
Case submitted.